Hey, it's Kent Jones with Jones and Associates in Cleveland, Tennessee. We're at 423-424-1004. I'm going through a book that I wrote in 2015 and updated on personal injury in Tennessee. And I wanted to talk just briefly, and it's going to be very briefly, about what's commonly known as a slip and fall accident. In many cases, it's termed premises liability. But I'll give you two examples to let you know. Ordinarily, anything that we've discussed before regarding negligence that causes an injury is going to apply to a premises liability or slip and fall injury. They can become a little more difficult, and I'll give you some examples. Let's say that you're a long or short-term trucker, and you go to the diesel store to obtain gasoline. You're wearing a pair of leather boots and step out onto a pool of diesel fuel and sustain a very serious back injury. You didn't see the diesel fuel. That's one element of it. Did you see it? Was it the biggest defense is going to be open and obvious. Was it open and obvious? Was it something that you should have been aware of, and you just decided to step out on it? That can be a defense to your claim. The other thing is, did the company know about it? If they didn't know that there was a diesel fuel issue when you stepped on it and slipped and fell, then there could be another defense as well. Otherwise, like I say, go back into the rules of ordinary negligence. If they knew about it, failed to clean it up, you didn't see it, it should be a premises or slip and fall type injury case. It'll be traditional litigation where you'll allege negligence on their part and go through treatment for your injuries, and ultimately either end up in a settlement or go on to a jury trial on your case. Oftentimes, almost all the time, at some point in the case, a defendant is going to file a motion for summary judgment, and that pretty much means, was there a genuine issue of legal fact or not? It really gets more complicated than that under 2015 legislative changes and case law. But if there was a genuine issue of material fact for a jury to decide, then that's the jury's province. And if there is no issue of fact, then it's a matter of law for the judge to decide. In all cases, once summary judgment is granted, you do have the right to appeal, and usually that appeal, if you're in circuit court in Tennessee, is going to be to the Court of Appeals of Tennessee, where you'll file a brief and go up and argue, and if you are not successful, then it's the end of the case unless you try to get up to the Supreme Court, or it usually is the end of the case. And if you are successful, then it bounces back down into the circuit court, and you go forward towards a jury trial. That's all I'm going to say about premises liability right now. If you have any questions, You can always visit us on the web at www.kjonslawyers.com. Our phone number is 423-446-1004. Thanks a lot. I hope everyone has a great day.